The officer blocked the door at 8:09 on a Monday morning and said, "Ma'am, this entrance is for attorneys and court personnel only." The woman in front of him was carrying a navy leather briefcase in her left hand and a paper cup of coffee in her right, and she had been walking through that entrance for 9 years. She said, "I know." She tried to step around him. He moved with her. He said, "I'm going to need you to go around to the public entrance on the south side of the building." She looked at him. He was new. She had not seen him before, which meant he had not seen her before, which meant he had looked at her and drawn his conclusion entirely from what she was wearing, which was a charcoal blazer, dark slacks, and a pair of low-heeled shoes she had bought from a rack at the Goodwill on Kenmore Avenue for $8. She said, "I am not a member of the public." He said, "I'm going to need you to move along." She said, "My name is in this building." He said, and he said it the way a man says something when he is very sure of himself, "Ma'am, you don't belong here." She did not argue. She did not explain. She reached into the inside pocket of the blazer and produced a laminated badge on a silver clip. She held it up. He squinted at it, and then, from somewhere above them both, a door opened on the landing at the top of the courthouse stairs, and a voice called down, not loud, not unkind, the way you call to someone you have already been watching. "Adeze, come on up." The officer looked up at the landing. He looked at the badge. He looked at the woman in front of him, who had already begun climbing the stairs. He did not follow. What the officer had not known when he put his body between that woman and that door was that the person calling her name from the top of those stairs was a federal judge who had been standing there for approximately 40 seconds watching the whole exchange. What the woman in the charcoal blazer had not known was that, in 13 minutes, she would be sitting in courtroom 7 at the right hand of that judge, and the first case on the morning docket would be a motion brought by the same precinct the officer at the door reported to. Her name was Adeze Chinwe Obi, and she was 44 years old, and she had been a public defender in the Cuyahoga County Felony Trial Division for 9 years, 4 months, and 17 days. She was 5'3", 127 pounds, and she wore her hair in a low bun, held with a single tortoiseshell pin her mother had sent from Enugu in a brown envelope, along with a note that said only, "This belonged to your grandmother." She wore it to every examination. Adeze had worn it to every court appearance since 2017. She smelled of the cocoa butter she applied every morning after her shower and, faintly, of the black tea she had been drinking since 5:45 a.m. At the kitchen table of her apartment on East 105th Street, going over her notes for the morning's motions, while her upstairs neighbor's dog walked in slow circles above her head, at a pace she had come to find reliable, like a clock. The briefcase was navy blue leather, scuffed at both bottom corners in the specific way of a bag that has been set down on courtroom floors and conference table edges for almost a decade. She had bought it new in 2015, the week she was hired, for $54 from a clearance shelf at a luggage store on Euclid Avenue that had since become a cell phone repair shop. She had never replaced it because the handles were still intact and the zipper still worked, and she was not in the habit of replacing things that still worked. Inside it were the case files for 4 separate clients, 2 motions to suppress, 1 sentencing memo, and 1 evidentiary hearing, along with a yellow legal pad covered in her own handwriting, which was small and slanted, and which her supervisor had once described, reading over her shoulder, as looking like a seismograph or a very calm earthquake. She had grown up in Akron, Ohio, the second of 4 children of Amika and Kioma Obi, who had emigrated from Anambra State in 1977 with $340 in a money belt, and the understanding, as Amika used to put it, that the understanding was the only thing they could not leave behind. Emeka had worked at a rubber plant in the Summit County Industrial District for 22 years. Kioma had worked at a dry cleaner on Exchange Street for 14 years, and then opened her own alteration shop in 1998 that was still operating, that still had a handwritten sign in the window that said alterations, all fabrics, same week turnaround, and that Kioma ran alone 6 days a week at the age of 71. Adeze had watched her mother press other people's clothes for as long as she could remember. She had watched her do it with the same care and the same quiet and the same lack of complaint, regardless of whose clothes they were or how they had been treated before they arrived. Everything that comes through here leaves better than it came, Kioma used to say, hanging a finished blazer on the rack. That's the only rule. Adeze had taken that rule with her to law school, to the bar exam, and to 9 years of standing in courtrooms on behalf of people who needed someone in their corner who would not leave. Her clients were not wealthy. They were not connected. They were, in the majority, people who had arrived at the criminal justice system the way most people arrive at it, not through a front door, but through a series of smaller doors, each one closing a little faster than the one before, until they were inside a room they had not intended to enter and could not find their way out of alone. Adeze had been in that room with 847 of them over 9 years. She kept a list, not of outcomes. Outcomes were not always in her control, but of names. Every client she had represented was written in a notebook she kept in the bottom drawer of her desk at the public defender's office on Rockwell Avenue, in black ink, in the same small seismograph handwriting, 2 columns per page, first name and last. The notebook had 847 entries. She was on her 3rd notebook. The courthouse at which she had been blocked that Monday morning was the Cuyahoga County Courthouse on Lakeside Avenue in Cleveland, Ohio. A gray stone building 8 stories high, with a lobby that smelled of industrial floor polish, and the particular stale warmth of a building that has been running its heating system since October. She had walked through the attorney entrance of that building, on average, 4 times per week for 9 years. She had walked through it in February, when the wind off Lake Erie hit the building at an angle that made the door hard to open, and she had walked through it in July, when the stone steps radiated the heat they had been storing all day, and she had walked through it on the morning her father called to tell her he had been diagnosed with a condition that would require surgery, and she had walked through it 2 days after the surgery, when he was stable, and she had not missed a scheduled appearance in 9 years, 4 months, and 17 days. Not once. The officer who had blocked her that morning was new to the building, assigned 3 weeks prior from a precinct reassignment. His name was on a tag, R. Pruitt. When Officer Pruitt moved his body to match her step, there were 4 other people within direct line of sight of the exchange. A paralegal named Gale from the Cuyahoga County Prosecutor's Office, who was 5 feet behind Adeze on the same path to the same door, watched the whole thing and kept walking until she was 3 feet from the door, and then stopped. She looked at Adeze. She looked at Officer Pruitt. She knew Adeze by face. They had been in the same building for years, and she put her hand on the door handle, but did not open it, because she was not certain enough, or perhaps not brave enough, which are sometimes the same thing. A man named Jerome, a process server, who came to the building twice a week, was already inside the lobby, looking through the glass, and saw the whole exchange from the other side of the door, and did nothing, which is also a kind of action. A second officer near the security desk, 15 feet inside the lobby, had heard Officer Pruitt's voice, and had looked up, and had then looked back at his desk. He was 3 years away from his pension. Officer Pruitt said again, with more patience than the first time, as though the problem were that she had not understood him, ma'am. The public entrance is around the south side. This is for court personnel only. He was not raising his voice. He was not being unkind. In his own estimation, he was doing his job, which, as far as he understood it, was to keep the attorney entrance clear of people who did not belong in it. He had looked at a charcoal blazer and a scuffed navy briefcase and shoes from a rack at the Goodwill on Kenmore Avenue, and he had made a determination. And the determination felt correct to him, and the only evidence he had to the contrary was the word of the woman he had already decided was wrong about where she was supposed to be. "You don't belong here," he said. He said it firmly, not cruelly. Firmly. Adeze reached into the inside pocket of her blazer and produced the laminated badge. The voice that had called her name from the top of the stairs belonged to Judge Miriam McCabe Solis, a federal judge of the United States District Court for the Northern District of Ohio, who had been appointed to the bench 14 years prior, and who had, in those 14 years, developed a reputation in the legal community of Cleveland for two things: a written opinion style so precise that first-year law students were assigned her decisions in legal writing courses, and a personal quality that her clerks described variously as stillness, weight, and, in the case of one particularly honest third-year clerk, the feeling that she already knows how this ends. She was 61 years old, Igbo Mexican, the daughter of a retired civil engineer from Lagos and a retired school teacher from Guadalajara, and she had spent the last 14 years being the person in the room who decided things. She wore her robes with the same quality of naturalness with which some people wear their own skin. She had been standing on the landing when she looked down and saw Officer Pruitt's body between the attorney entrance door and Adeze Obi's briefcase, and she had watched for 40 seconds before she opened her mouth. 40 seconds had been enough. She had not called Adeze's name to make a point. She had called it because Adeze was a person she had worked with for 9 years, and because there was a motion calendar starting in 13 minutes, and because the simplest and most direct way to end the situation at the door was to make it unambiguous that the woman Officer Pruitt was. Blocking was expected upstairs. That was the whole calculation. It had taken less than 1 second. If what's happening in this story is already doing something to you, stay with me, because what happens inside Courtroom 7 is the part that closes the circle. Courtroom 7 was on the 4th floor of the Cuyahoga County Courthouse, and it held 64 seats in the gallery and smelled on Monday mornings of the overnight cleaning crew's work, pine and something slightly chemical, and underneath it, the ghost of decades of proceedings, of voices raised and lowered, of verdicts delivered, and lives redirected. The fluorescent lights in Courtroom 7 ran slightly warm, which made the wood of the gallery benches look more amber than they were, and gave the room a quality that a visiting attorney once had described as solemn without trying. Adeze had been in this room enough times that she noticed it the way you notice a smell when you first walk into a house you have lived in for years, briefly, and with something like affection. She was at the defense table at 8:21 a.m. Her client that morning, for the first motion, was a 23-year-old man named Tobena Nwosu, who had been charged with possession of a controlled substance on the basis of a traffic stop on East 55th Street on a Tuesday night in November. Tobena had been driving home from a shift at a warehouse on Brook Park Road where he had been working for 8 months, $17.40 an hour, the first steady job he had held in 3 years. The stop had lasted 9 minutes and 22 seconds. The officers had found nothing in the car during the first search and had called for a second unit, which arrived and conducted a second search. They had found a small amount of a controlled substance in the space between the driver's seat and the center console. Tobena had maintained from the beginning that it was not his. Adeze had not told him whether she believed him, because it did not matter. What mattered was whether the stop itself was lawful, and she had 11 days of work suggesting it was not. She had filed a motion to suppress the evidence from the stop, arguing that the officers had lacked reasonable articulable suspicion for the initial detention. The dashboard camera footage from the patrol car showed the trigger for the stop, the vehicle drifting toward the center line. Adeze had watched the footage 41 times. She had measured the drift using the lane markers visible in the footage. The drift was approximately 4 inches. She had the timestamp and the measurement written in the legal pad. She had the case law for what constituted reasonable articulable suspicion in Ohio, tabbed in 4 places in the file, and she had the relevant statutes in longhand on the top sheet of the legal pad, in the order she intended to introduce them. Tobena Nwosu was sitting in the gallery that morning, 3 rows back, wearing a white button-down shirt he had ironed carefully and a pair of dark slacks that were slightly too long. He was 23 years old, and he was watching Adaese's back at the defense table with the particular stillness of a person who has placed everything they have into a set of hands they hope are the right ones. Courtroom 7 smelled on Monday mornings of the overnight cleaning crew's work, pine and something slightly chemical, and underneath it, the ghost of decades of proceedings, of voices raised and lowered, of verdicts delivered, and lives redirected. The fluorescent lights ran slightly warm, which gave the wood of the gallery benches an amber quality and made the room feel, to the people inside it, like something between a library and a church, a place where you kept your voice low, not because you were told to, but because the accumulated weight of what had happened in it demanded it. Adaese had been in this room often enough that she noticed it the way you notice a smell when you first enter a house you have lived in a long time, briefly, and with something close to recognition. The attorneys representing the city on the motion were 2 men from the city prosecutor's office whose names were on the docket. The lead attorney was 51 years old, had been in that office for 19 years, and had won 3 of the last 4 suppression motions Adaese had brought in front of Judge Achebe Solis. He was not dismissive of her. He was thorough, and he knew the law, and he had come prepared. That was what made it hard. The system, at its most impenetrable, is not the one staffed by careless people. It is the one staffed by careful people who are careful in its service. He opened his response to her motion by citing 3 cases from the Sixth Circuit, in which 4-inch lane drifts had been held to constitute sufficient basis for a stop. The cases were real. Adaese had them in her file. She had read them the same night she measured the footage. She had also found, in her reading, a distinction the city's attorney had not addressed. In 2 of the 3 cases he cited, the drift had been sustained for more than 4 seconds. In the Nwosu footage, the drift lasted 1.8 seconds. She had written the timestamp in red ink at the top of the relevant tab. It was when the city's attorney finished, and Judge Achebe Solis turned to Adaese with the particular quality of attention she brought to the moment before a response, a quality that resembled patience, but was actually something more active, more like listening forward, leaning toward the answer before it arrived, that the motion turned. Adaese stood. She did not look at her notes. She had already done the work of making the notes unnecessary. She argued for 19 minutes. The city's attorney responded for 11. Judge Achebe Solis asked 3 questions, 1 to the city's attorney, which he answered in 2 sentences, and 2 to Adaese, which she answered in 1 sentence each. Because the answers were 1 sentence each, and she had learned a long time ago that the most powerful thing a person can do in front of a judge who has already understood the argument is stop talking. Then the judge said, "I'll take it under advisement," and made a note on her pad, and called the next matter. After the docket cleared at 11:47 a.m., Judge Achebe Solis did not immediately leave the bench. She finished the last of her notes, capped her pen, and set it on the docket book. Then, she looked at Officer Pruitt's name on the incident report her clerk had placed before her during the second recess. Adaese had submitted it through the clerk's office at 9:05 a.m. 2 paragraphs. Factual. No editorializing. The judge read it once. She looked at the docket and found the name of the precinct captain. She wrote 3 sentences on her judicial letterhead. Her clerk sent the letter at 12:02 p.m. The letter stated that an officer under the precinct's command had that morning detained a licensed attorney at the attorney entrance to the Cuyahoga County Courthouse, denied her lawful access to the building on the basis of an assessment that had no evidentiary basis, and told her directly that she did not belong here. The letter noted that this action had occurred at a building where Judge Achebe Solis presided, and where she had personal knowledge of Adaeze Obi's standing as an officer of the court. The letter requested a formal response within 10 business days, and stated that the response would be entered into the court's correspondence file. The precinct captain responded in 7 days. The response acknowledged the incident, stated that Officer Pruitt had been counseled and would receive additional training in identifying credentialed court personnel, and offered a formal apology to the attorney in question. The response was 3 paragraphs. The third paragraph, the one with the apology, was the shortest. Adaeze received a copy of the apology on a Thursday afternoon at the public defender's office on Rockwell Avenue. She read it once, set it in the file she kept for administrative correspondence, and went back to the brief she was writing for the client in the second notebook, page 34. A 58-year-old woman named Constance, who had been waiting 11 months for a hearing date, and to whom Adaeze had promised, in a phone call the previous week, that they were not going to wait 11 more. The motion to suppress in State v. Nwosu was granted 14 days after the hearing. The evidence from the traffic stop was excluded. The charge was subsequently dropped. Tobena Nwosu was 23 years old. He had a job at a warehouse on Brook Park Road that paid $17.40 an hour, and that he had been holding for 8 months. He kept the job. His name went into the notebook in black ink, in the small seismograph handwriting, in the right-hand column of page 57. Officer Pruitt still works at the Cuyahoga County Courthouse. He works the public entrance on the south side of the building, not the attorney entrance. Whether he made the connection between the woman he stopped on the stairs and the ruling that came out of courtroom 7 that same morning is not recorded anywhere. What is recorded is the letter in the court's correspondence file, the entry in the notebook on page 57, and the fact that on the Tuesday after the motion was granted, Adaeze Obi walked through the attorney entrance of the Cuyahoga County Courthouse at 8:06 a.m. with her navy briefcase and her paper cup of coffee and the tortoiseshell pin her grandmother had worn to every examination, and she walked up the stairs without anyone stopping her, and she went to work. Some people spend years learning to recognize authority only in the forms they were taught to expect: the expensive suit, the pressed collar, the car that matches the parking space. They never learn that authority is not a costume. It is accumulated. It is carried. It sits inside the file that has 847 names in it, inside the brief that took 11 days, inside the 19-minute argument that contained every relevant fact in the order it actually required. You cannot block a person from a room they have been building their whole life. Officer Pruitt looked at a charcoal blazer and Goodwill shoes and a scuffed briefcase and saw someone who did not belong. He did not see 9 years. He did not see 847 names. He did not see a grandmother's pin, or a 5:45 a.m. kitchen table, or a mother who pressed other people's clothes for 26 years and raised a daughter who understood, from watching her, that everything that comes through here leaves better than it came. There is a person in your life who has been standing at a door someone put their body in front of. Maybe it is you. Maybe you have been that person today, this week, in the last year, carrying everything it took to walk through that entrance, and being told by someone who read only the surface of you that the room on the other side is not yours. It is yours. It has your name in it. Sometimes the name is in a docket. Sometimes it is in a notebook in a bottom drawer. Sometimes it is called from a landing by someone who has been watching long enough to know exactly who you are and precisely where you are supposed to be. The people who have been blocking the door do not always know that the person calling your name from the top of the stairs has 14 years of authority and 3 sentences of judicial letterhead and is already writing. If someone has ever told you that you don't belong in a room you had earned, leave your answer in the comments. What did you do? Did you explain? Or did you simply keep walking? Subscribe for more stories about hidden strength, quiet power, and the people this world overlooks until they change everything. I'll see you in the next one.